right, good morning, everyone. I still don't have the calendar with the recommendations on it. Can somebody send me that?
Your Honor, I did. If you look at it, it say SAP. I'll tell you when I send it to you. It doesn't say it's normal thing. I just sent it at, or maybe I didn't send it.
It says, okay, I got it now. I see it.
Okay, yes,
All
ma'am.
right, I'm ready to begin. Good morning, everyone. This is the state all-purpose calendar in the state court of Fulton County, Georgia. I'm Judge Melanie Williams. And at this calendar, we will address matters. For those people, we will address cases and see if we can take pleas to resolve some matters. Other cases will be arraigned and reset division. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at the proceeding here today. As you can see, I am appearing by video. I am not there in person with you. That means any member of the public can log on and watch this particular proceeding. It's being recorded and live streamed. When I ask if you understand your rights, this is what I'm referring to, whether you understand your rights to an attorney and whether you understand how I'm conducting the hearing today. All right, who do we have first?
We can start with position 17, Mr. Forbes.
Good morning, Your Honor.
All right, good morning. That's your client.
Yes, Your Honor.
Thank you. And what is the announcement for your client, Mr. Forbes? Will he be taking a plea today?
No, ma'am. If I'm no judge, if may I speak to, I have the opportunity to speak to the prosecutor for a second.
Okay. I don't know if Miss B, are you here alone today?
I am here alone today.
Okay, Mr. Begway, I don't know that she can speak with you right now, only because she's here alone for the entire calendar. Is there an offer that you would like to put onto the record, Miss Spear?
The current offer is 12 months probation, credit for time served. I show that he served 7 days, so we will give him credit for 14. No further violent contact with the victim, as the victim is his father. MHET, as it was originally called in as an MH potential issue. And I do show a note that he has an open ag assault in Fayette County.
Okay, so I'm assuming you reject that offer and wish to reset this case to a division judge for further development.
Judge, may I just address the issue of the bond, Your Honor?
All
I
right, so you'd like to
understand
be
that.
heard. All right, you'd
Yes,
like to
Your
be
Honor.
heard on bond. All right, hold 1 second then. Let's do this with some order. All right, Mr. Forbes, your case is 26 CR 002984E. You're charged with simple assault, family violence. Do you understand the rights as I just explained those a moment ago?
No.
Is that a yes, Mr. Forbes?
No. Okay.
You don't understand your rights?
No.
Okay, you have a right to remain silent. You have a right to an attorney, and your attorney is present. You understand that?
Yes.
All right. Ms. Stallworth, can I have his history, please? Number 17.
Yes, Your Honor. Good morning.
Good morning.
He has one prior arrest, and then there's an open case out of Fayetteville for aggravated assault and hit and run. Nothing further.
All right, thank you, Ms. Spear. Your position regarding his bond.
I don't have a note on what his current bond is.
It's $5,000 cash bond, Judge.
Okay.
We are just asking that the bond might be reduced maybe for $2,500 or max at $3,000. The father, who is alleged victim, also has logged in somewhere. Mr. Forbes, are you there?
I am.
All right, hold 1 second. Ms. Spear, please continue with your position.
Based on concerns of MHET and the open felony, we would ask that it remain the same.
Okay. All right. I'm sorry, and the name of the alleged victim is?
Mr.
Michael Forbes.
All right, Mr. Forbes, if you'd like to speak to the court today, I need you to turn on your camera. Please raise your right hand. All right, Mr. Forbes, please raise your right hand. Do you swear or affirm? But you're muted as well. You're going to need to unmute. You're still muted. All right. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I do, Your Honor.
All right. What would you like to tell me at this time?
Okay. Me as his father, I'm advocating for him to first and foremost to not be convicted. Second of all, he was involved in the
You need
incident
to
with
face the camera, Mr. Ford. Can
Okay,
you face
okay,
good?
okay, yes. Yeah, of course he did have an episode, but he didn't actually hit me. And so even though he's arrested, I would like for him to see if the court could consider giving him a bond. Considering some of the history of Fulton County Jail, I also used to work there, and just to be detained in Fulton County Jail, it's not the best interest. And I spoke with his mom and attorney, and there are some voluntary counseling service that we're going to get him. So I'm asking you to lower the bond so we can get him out, and we can get him to some counseling services. And in regards to the Fayetteville case, in regard to the Fayetteville case, it was actually his girlfriend who was at fault, and
You probably don't want to say too much about
okay,
that.
okay, I
I
got you, I
think,
got you.
you
All right,
know,
thank you.
yeah, it's best to let your attorney
Yes.
finish that up. Okay. All
All
right, Mr. Begway, is there anything else you want me to consider?
Judge, if the court will, indulge Mr. Ford and myself as the advocate for him, we are asking the court to reduce his bond or let him sign his own bond. That is the fact that he's also a law enforcement officer, so he knows better not to. Once in a while, the father suggested also the child, I call him a child for a good reason, because I was involved in the case, alleged case in Fayette County, which according to the state, that the case is still open. To the best of my knowledge, Judge, that case was resolved in favor of my client. And we're just asking the court either to let him sign his own bond or reduce the bond to $2,500 so they can afford it, Judge.
And it's a cash bond currently? It's not a surety bond?
No,
Let me look.
no, Judge.
Let me look.
The economy is tight, you know what I mean? The father is willing, the mother, they're trying to come up with something. As of 2 days ago, they came up with $2,000 only, and we're just asking for 25, half of that money, Judge, or let him sign his own bond. It's not going anywhere. It's not going to run away. And the idea of the bond is to bring him back. This is the alleged victim also who I just spoken to the court.
Right. I understand. I need to look at one thing. Ms. Strong, will you please look at your chat for me?
One moment.
And I know that counsel, you said that he had is he currently, you said that he will be released and going into some type of treatment. There's a treatment plan in place for this defendant.
Yes, Your Honor.
And what is the nature of the treatment plan? Is it inpatient, outpatient? What does that treatment plan look like if he is released or if I lower his bond?
Mr. Ford, can you please address the
Yes.
court on that issue?
Yes, Your Honor, I spoke with the counselors and the director at the Salvation Army. It's a partial outpatient and voluntary inpatient program. So it's a real good program. He'll stay there for 30 days. After 30 days, he'll work, and he has the freedom to go back and forth, but come back at I think 11 or 12 midnight curfew. So it's a good program, and some of the individuals in there who I know had some challenges, they're doing really, really good. So
Right. Ms. Spear, what were the conditions on the original bond?
Oh, let me pull it up real quick.
That's what I'm trying to get to load, and it's not been a great. Ms. Strong or Ms. Young, what are the conditions? Anybody can tell me what the conditions currently are?
It says he's to have no violent contact with victim's family, close associates, by email, social media, or through third party.
Okay, what we're gonna do is we're gonna turn the cash into a surety. It'll be a $5,000 surety bond. with those same conditions. Okay?
Thank you, Your Honor.
All right, is there anything additional from either party?
Not from the
from me.
defense, Judge.
All right, best of luck to you in council. Does that conclude your business today?
Yes, Judge.
Take care. Have a good
Thank you, Judge.
afternoon.
You too, Judge.
All
Your
right,
Honor,
bye-bye.
Your Honor, sorry for the interruption. The attorney does know he needs to send the bond order to Ms. Strong, correct?
Can we do a form bond order for this, please?
Yes, Your Honor.
Okay, thank you. All right, take care. Have a good day.
Thank you.
You too, Your Honor.
All right, who do we have next?
We have position number 9 and 10, Mr. Dodson.
All right, I don't have an announcement for that. What is our announcement for Mr. Dodson?
Gonna be a negotiated plea, Judge.
Oh, you're at the jail, Mr. White? Is that you? Okay.
Yes, we had issues with getting everybody spoken with yesterday for a number
Okay.
of.
I'm just used to seeing your nice background at your wherever you are. All right, let's proceed. Let's see. Mr. Dodson, your case is 25 CR 006762J. In that case, you're charged with theft by taking. You also have an FTA case. Do you understand your rights today?
Yes.
All right, Ms. Spear.
Yes, Your Honor. In exchange for the plea on position 9, we are agreeing to dismiss the FTA matter, which is position 10. On position 9, 25 CR 006762J, state's recommending 12 months probation, credit for the 3 days that he has spent bounds probated, anti-theft course, $1,100 in restitution to the victim, Clarissa Dobson. That is his mother, for the iPad, which he took and subsequently sold.
All right, Mr. White, that was your understanding. You so stipulate to those 3 elements?
We do, Judge, and we would ask to waive 3 or 4 months of his probation fee so he can apply that to replacing the iPad, and then after this probation to terminate once he completes that payment and the theft course.
All right, I'm gonna waive 1 month, Mr. White, and then he can go non-reporting once he has completed all the requirements. Okay? All right, thank you. Mr. Dodson, please raise your right hand. I'm asking you some questions, make sure you wish to take a plea, okay? Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
You understand you're giving up your right to trial by judge or by jury,
Yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt,
Yes.
and you fully understand all the requirements as explained to you by your attorney, Mr. White?
You understand? Oh, yes.
All right. As to the charge of theft by taking, how do you plead, sir? I accept your guilty plea. Is there anything additional, Ms. Spear or Mr. White?
No, Your Honor.
No, Judge.
All right. Best of luck to you, sir. That concludes your case.
Thank you, Your Honor.
And next we have number 1, Mr. Baker.
Mr. White, I sent you kind of a late email last night on Mr. Baker. Did you happen to get it?
I did.
Okay.
I just think we.
What's our announcement for Mr. Baker?
It's going to be a plea, Judge.
Okay, hold on 1 second. Has this case been previously reset?
Yes, Ms. Law,
And
Judge Law,
Judge Law had some concerns about the offer.
she rejected the plea last week, Judge.
Okay, and are we back with the same offer that Judge Law rejected?
It is not. There's looks like an additional requirement of I believe it's only 1 victim impact panel. Correct me if I'm wrong, but the 2 AA meetings a week are a new
requirement. Let me just take a she
And
she said she's very concerned about this one, so I want to just make sure I take a look.
It's my understanding that an ignition interlock was also mentioned last week, which is what I emailed Mr. White last night, that was likely to be a requirement that I had left off. And I had also offered DUI court.
And he's rejected DUI court is what I have. Was there something in the offer for monthly screenings?
No, I didn't have that in there.
What's the current offer that you all have agreed to? What's the offer?
12 months probation, serve 90 days, ADET, risk reduction, $750 fine, 240 hours community service, 2 victim impact panels, 2 AA meetings a week, and the ignition interlock for the DUI.
Okay. Let me see. Hold on one second. And the second charge was going to be consecutive or concurrent?
It's concurrent as far as I'm aware.
Yes, concurrent,
Okay.
that is correct.
Okay. This is difficult for me because again, I wasn't here last week. The indication I had is that she rejected anything that would have been a concurrent charge. This is just
Okay.
what I'm reading, and it's indicating that it's really hard when I'm following behind somebody. Okay, the notes that I have received from her is that she rejected any plea arrangements that would have had a would have had a concurrent charge. She's also rejecting anything that did not have random screenings. Did she make the parties aware of that last week?
I don't show that note, but I wasn't here last week either, so.
Neither was I. So
Judge-
it's difficult.
I can't say certainly, but I do not remember that being an issue, the concurrent versus consecutive. So I think there was consecutive was brought up and we agreed. And then for some reason, she just decided to reset the case.
She's reset it because she said that she's rejecting the offers. She does not feel that what was proposed by the state was sufficient in light of the fact that he's got 4 DUIs.
Well, Judge, my information is not that he has 4 DUIs. He has a conviction from 93, one from 21, and he does have one other open case.
All right,
So this would
Ms.
be his
Stallworth,
third-
can you get let's run it through pretrial really quickly. Ms. Stallworth, can you give us this history, please, for Mr. Baker?
Yes, Your Honor. He has 11 cycles total, 1 from the state of Florida. There is an active warrant out of Coweta County for a probation violation. Date of that warrant is August the 1st of 2023. There is a 2022 conviction out of Coweta County for DUI and driving while license suspended or revoked. A 2012 conviction out of Gainesville for driving while license suspended or revoked. 2011 NOLO out of the city of Atlanta for driving without valid license. 1993 out of Fulton DUI. 1985 out of DeKalb abandonment of child. That's all I was showing on the
So-
GC.
So that was 2 DUIs that you saw, Ms. Stallworth?
2 convictions, yes, Your Honor.
2 convictions and 1 open case?
Well,
Yes.
she has the 2022 as a guilty. So
As a
this would
guilty.
be his 4th in life, 2nd and 10.
Okay. 4th and life, 2nd and 10.
I
Okay.
showed that the Coweta one was open, but I did get a note from one of my colleagues that said she thought that he had pled to it, and it looks like that's what pretrial is
What
showing.
has
that he pled.
happened? Okay.
So my open was based on the states.
Right, understood. Understood. So that's 4 in life.
Mhm.
Okay, hold on. I'm so sorry. I'm trying to cobble this together with what this says. Okay. The notes I have is that she specifically rejected an offer that was not concurrent. I mean, that was not consecutive and did not require the mandatory screenings as well as the interlock. So with that said, Mr. White, if those requirements are placed upon your client today, does he wish to take the plea or does he wish to be reset to a division?
I'm sorry, can I have 1 minute?
Yes, I understand. And the only reason I don't want, what I do want is I don't want us to judge shop a little bit. I want to make sure that, we stick with what she decided last week.
I mean, I will point out, she's the one who reset it for a week. I don't know if she knew she would be here, or not, but we Judge, he's willing to go forward with that.
He is, okay. All right, so as explained, I'll send this email to you, Ms. Strong, so that we can get the language correctly. But the understanding I have is that he's gonna, she has the time in jail different. What was the current offer? How many additional days was he gonna have to serve in jail?
24 more days, Judge.
24 more days.
I don't think so, because if we're doing 10 days consecutive and another 10 days, that's 120 days total.
Right, so that's not gonna work either.
So I don't think it was about the jail time. I think it was about the probation as far as.
Right, it's right. So, but she was actually under this. How much time has he served?
He's been in jail 3 weeks now, Judge.
Right, so she was fine with it. It looks like this was going to be time served. Last week, it looks like it would have been time served with these requirements, but that's not what's on the table today. It's really difficult when you're trying to put together what happened when you weren't there.
I believe this, and I'm almost certain this was a 90-day sentence last time.
That's
Okay.
part of the problem, is because she didn't want the 10 days concurrent. It sounds like to me what I'm hearing is she doesn't want the 10 days for the suspended license and the failure to obey to run concurrent. She wants them to run consecutive, which is another 20 days onto the 90 days.
Well, that would be 5 days.
No,
Well,
right.
yeah.
Well, that part, I think she's more concerned, I think, about the fact that she wants him to be on probation for the 2
Right.
years versus the jail time. Right.
Yeah.
I don't think she cares about the jail time. The offer that I have does not say it was a 90-day sentence. So I'm trying to figure out how to. The offer I had was pretty much he was going to get out of jail but be on probation for 2 years.
Okay.
Here's what I'm going to do. I'm going to email this to Mr. White and Ms. Spear, just what she said, because this is the information I have from last week.
Judge, can you email that to Mr. Dodd, because my computer.
Oh, because you don't have a way to look at it. Okay, I'm gonna look at it and I'm gonna ask you both to take a look at it and see if this is consistent with something you can agree on, and if this is consistent with what you have for notes for last week. And then we'll come back to Mr. Baker. And I apologize. We should have addressed this prior to court. Let me send this. And I'm literally just going to cut and paste this in here, and I'm not going to put any subject. So please tell Mr. Haddad this is coming.
Okay.
And Ms. Spear, this is coming. And just take a look at it, and then we'll come back to Mr. Baker in a moment. All right?
Thank you, Judge.
Thank you.
Thank you.
Email for me, but my computer won't.
All right. Can we take another case?
We go to position number 11, Mr. Douglas.
And Your Honor, Mr. Douglas will be entering this morning. We are asking him to be allowed to enter
I'm sorry, you're asking to be allowed to enter.
a NOLO, Judge.
And what is the state's position regarding a NOLO?
State would object based on history.
Okay, hold on.
Does that mean he's NOLO within the last 5 years?
Who is this?
No, he's eligible, just that because he has.
They don't like it. All right, let's
What position is this?
11. All right, Mr. Douglas, your case is 26 CR 002804H. In this case, you're charged with theft by shoplifting and criminal trespass. I understand that you wish to take a plea today. Before we take it, I'm going to hear your history to see if to resolve the issue of whether a NOLO will be permitted. Ms. Stallworth, can I please have the history for Mr. Douglas, please?
Yeah,
Sorry,
sure.
Mr. Douglas.
He has 8 cycles total. There's an FTA in 2026 out of Dunwoody. There's a 2026 conviction out of Dunwoody for theft by shoplifting. And there, one moment. Nothing further from the GCIC.
I'm sorry, there was a theft by shoplifting. When was the last theft by shoplifting?
I think, hold on, let me pull it back up. I think it
I
was,
have 2025 Decatur, 2025 Dunwoody, and I missed the last thing you said.
that theft by shoplifting was 2026 from Dunwoody Municipal.
Okay, so 3 theft by shoplifting in the last year. And he pled guilty. All right, Mr. White, I am inclined to agree with this.
I've got 2 of those 3 being open, so they're not convictions.
Ms. Stallworth, are they open or are they convictions?
The only conviction, the one that I told you, was the theft by shoplifting out of Dunwoody. That was, he took a plea on January the 28th of 2026. The other ones are open.
All
The
right.
one out of Decatur and
So
then
all right, so just one. And what was he alleged to have taken in this case, Ms. Spear, for the value of the item?
I don't have a value, but I can look it up real quick. Hopefully Odyssey allows me.
We don't need it. Right? You just what's that?
I'm assuming he
Yeah,
took something from Target.
Yeah, I'm looking it up right now. Okay, here we go.
while you're waiting on her, he is currently on probation for battery family violence.
No.
That case number is 25 CR 005684H.
Okay. I think I remember this case. All right, Mr. White, I'll allow him to use his NOLO plea if he wishes to move forward today, okay?
Thank you, Judge.
Yeah,
All
it
right.
was less than $40, Your
Yeah,
Honor, and it was mostly food.
Yeah, I remember. He can use his NOLO plea.
I knew it was under 50, but I wasn't sure.
I looked up my notes myself because I think I set his bond at one point. All right, Mr. Douglas, please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
By taking a plea, you understand you're giving up your right to trial by judge or jury,
Yes.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yeah.
And you understand that, do you fully understand the requirements of the sentence? Ms. Beer, I'm not sure we had you put the offer onto the record. Will you go ahead and put the offer onto the record?
Yes, count 1, theft by shoplifting. State is recommending 12 months probation. Credit for time served. I show 14 days. It may or may not be accurate. A $500 fine as required by statute. Stay away from all target locations. On count 2, criminal trespass. Credit for time served.
All right. And Mr. White, you do stipulate, and that was your understanding?
It is, Judge. He's actually been in 21 days. At this point, it was 14 days as of 15th. He is. We would ask to convert the $500 fine to 50 hours of community service and as his probation terminate or go non-reporting once he completes all.
All right, and I will allow it to terminate and I will convert it. Mr. Douglas, do you fully understand the requirements as just explained by Mr. Spear and discussed with you earlier by your attorney?
Yes.
All right, as to the charges of theft by shoplifting and criminal trespass, how do you plead? I accept your no-low plea at this time. Best of luck to you. Is there anything additional, Ms. Spear or Mr. White?
No, Your Honor.
No, Judge, thank you.
All right, best of luck to you, sir. That concludes this case. Who do we have next?
No, 13, 14, Mr. Duffy.
And I don't have an announcement for this one. Is this a negotiated plea?
It is, Judge.
All right, Mr. Duffy, your case is 24 CR 0000710F. You're charged with battery, and you also have 26 CR 002964F, in which you're charged with criminal trespass. Do you understand your rights today?
Right.
All right, thank you. Ms. Spear?
Yes, Your Honor. I was just checking. We got an email about a victim with a similar name yesterday, but I don't think it's the same one. I just wanted to verify real quick. The offer on the case ending 0710F battery, state recommends 12 months probation, serve 90 days. I believe he's met that. I show 48 days at least in his previous incarceration. 8-week anger management, 40 hours of community service, no further contact with the victim, Obi Anglin, and an MHET on case ending 2964F, position 14, credit for time served. I show 8 days on that. And he is banned from all Little 5 Points premises. We ask that he stay away and comply with that ban.
All right, Mr. White, was that your understanding of the agreement, and do you so stipulate to the 3 elements in this case?
Yes, and yes, Your Honor. We would, again, just that it, to waive 2 months of probation fees and ask that the probation go to non-report and terminate.
All right, does he have a stable address?
Yes.
Yes, Judge.
All right, I will waive the 2 months of fees. All right, Mr. Duffy, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, Your Honor.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, Your Honor.
Did anyone force you to take a plea?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
Do you understand that you're giving up your right to trial by judge or jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, Your Honor.
And you fully understand the requirements, including staying away from Little 5 Points and having no contact with Obi Anglin, completing 40 hours of community service, but you should not have additional time to serve in Fulton County Jail. Do you understand all of that?
Yes, Your Honor.
All right. As to the charge of battery and criminal trespass, how do you plead, Mr. Duffy?
Yes.
I accept your guilty plea. I am going to sound for Obi Anglin at this time. All right, hearing none. Best of luck to you. Is there anything additional from the state or defense?
No,
No, Your
Judge.
Honor.
All right, best of luck to you, Duffy. Have a
Thank
good
you.
afternoon.
No, next one.
Good morning, Your Honor. Next is position 2 and 3. Attorney Haddad's clients are over here, all the females for him.
All right, good morning. And has South Annex, I'm sorry, ACDC heard their rights?
Yes, they did, Your Honor.
Wonderful. Thank you so much. All right, and this is Miss Bourgeon. Am I saying it correctly? I'm so sorry if I'm not.
Good, John.
Ms. Bajong, your case is 25 CR 00563. I'm sorry, 5653Y. You're charged with simple battery against an officer and obstruction. You also have an FTA case. Do you understand your rights today?
Yes.
All right. Mr. Haddad, I'm sorry, Ms. Spear.
Your Honor, I apologize. This is not going to be a plea, Judge. I'm asking you for a bond hearing on this case under the
Okay.
circumstances of this case, Judge.
Thank you. I'm sorry, and I did know that it was a plea, so that's good that you let me know. Ms. Stallworth, can I please have the history for this defendant, please?
What position is this? I'm sorry, Your Honor.
2 and 3.
2 and 3. Okay, so just 32. One moment. Sorry, my computer's moving so slow. She has one cycle from the state of Florida. There are 2 cycles from the state of Georgia. There's an FTA in 2026, and the other case may be this one. Is this one? Nothing further.
One cycle, no
Yeah,
convictions.
no
Okay,
convictions listed.
understood. Thank you. Did Ms. Spear, what's her current bond? You're muted.
I was just pulling that up right now.
Oh, it's 2,500.
2,500 surety?
Yes, Judge.
That's probably in light of the FTA. I do have a note that she is residentially challenged, and with the other out of state history, that's probably where the concern came from.
It should be more than 2,500 because if she's got the FTA is now going to be holding her too, correct?
Your Honor, the
FTA is what's holding her.
Yeah.
And that probably doubled, right?
Judge, I don't believe so. The jail has her at $2,500 on the FTA. That's the only thing that's keeping her in custody. When she was first arrested, Judge, she was released through a signature bond through the jail.
Does she have you said she's residentially challenged. Does she have a stable address now, Mr. Haddad, or we're gonna have the same?
No, she does, Judge. Her mother lives locally, Judge. And she was released on a signature bond back in I think November. She had moved, and that's basically how it was. She missed court. She turned herself in to Cartersville Police Department, Judge. I don't have any proof, but she says to me that she did turn herself in. She was transported to Fulton County. She's been in custody a total of 11 days, Judge, 8 days for this time around and 3 initially. The concern, Judge, is that she is there's some immigration issues that if she were to resolve the case, that will affect her immigration status. The case itself she had placed the call because her cousin was going through some type of a drug overdose, and that's why the police responded, and it went downhill from there, Judge. She does not have any prior convictions. I'm asking for the opportunity to allow her to get a signature bond through pretrial services with all the conditions, Judge, so she can at least address these charges from the outside.
All right, Ms. Spear.
I show that she had a felony in AK's Arkansas. So we have that. It was dismissed, so it's not a conviction. Let's see. There's a second felony out of Anchorage. Let's see, charge 3 assault out of Anchorage. This is not a one-off, and with the I'm sorry, I said Anchorage, Arkansas. With the
This sounds very different from what Ms. Stallworth just read us.
Yeah,
I'm
I
showing
don't have any of those. I'm sorry.
That's okay. Out of Hillsborough, Florida, she has an out-of-state fugitive charge, which I'm guessing stems from all the charges in Arkansas. So with that and the FTA, she has several states worth of at least 3 states worth of history. And FTA residentially challenged. I'm not inclined to consent to the modification.
Right, she's shaking her head, and again, Ms. Stallworth, you didn't see any of that?
I don't see any of the Arkansas. I see the Florida. That's the only one that I have on my GCIC.
I don't believe there's an Arkansas connection, Judge, but
that's where her license is from, is what it shows in my.
Not. It's from Alaska. It's from Alaska. I've never been to Arkansas.
Sorry, AK's Alaska.
Okay. All right. Here's what we're gonna do. We're gonna let me think. So the position 2, she's got a signature bond. That's not holding her. The FTA is the issue, and the FTA is a $2,500 surety bond.
according to Odyssey, yes.
Okay. Um, so she doesn't need a bond order for number 2. I just want to make sure before, because this has come back a couple times to bite me. Okay, so position 2, I'm gonna indicate she's already made bond on that. Position 3 is what's holding her, the FTA. The FTA is currently a $2,500 surety bond. She's residentially challenged.
Yeah, Your Honor, at least that's not the indication that she gave me.
The only thing we have in Odyssey is the city of Cartersville. That's it.
That's where her mother lives. But I can get the address.
All right, I'm gonna convert it to a $2,500 signature bond level 1 through pretrial services with the same conditions, okay?
Thank you, Judge.
All right, best of luck to you.
Thank you.
Next is position 45, Miss Hope Rogers.
No. Your Honor, that is gonna be a plea, Judge.
All right, Ms. Rogers, your case is 26 CR 002981E. You're charged with criminal trespass in this case. You understand, rights? All right, Ms. Spear?
Yes, Your Honor. State's recommending 12 months probation, credit for time served. I show 7 days. That may or may not be accurate. No further contact with the victim, Kiora Collins, and I apologize if I said that first name wrong, and to stay away from 324 Autumn Lane.
All right, Mr. Haddad, that was your understanding, and do you so stipulate to the 3 elements?
Your Honor, we stipulate for the 3 elements, Judge. My calculation that Ms. Rogers has spent a total of 13 days, Judge. And I don't know if the court would be willing to consider suspending probation with the special condition of no further contact with Ms. Collins and to stay away. Essentially, what I'm asking for is a time served sentence, Judge.
I think that's what it was, right, Ms. Spear, or no?
I think there were.
We can do that.
Right, that's what it seemed like to me. Is it is bound suspended? That's what I was thinking.
I didn't say it, but yeah, it should be.
Okay.
All
right.
Thank you, Judge.
I
All right.
apologize, Mr. Haddad.
All right, Ms. Rogers, please raise your right hand. Do you swear or affirm the testimony given today will be the truth to the best of your knowledge?
Yeah.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No,
Did anyone force you to take a plea today?
no,
Did anyone promise you anything in exchange for taking a plea?
no,
And you understand you're giving up your right to trial by a judge or jury?
yes,
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
yes,
And you further understand that taking a guilty plea may affect other aspects of your life, such as employment, probation, immigration, or any open cases if you have those? All right, and you fully understand the requirements. Even though the time you serve will close your case, you are not to have any contact with Ms. Collins, and you are to stay away from the address on Autumn Lane. Do you understand that, Ms. Rogers?
yes,
As to the charge of criminal trespass, how do you plead?
yes.
I accept your guilty plea. Is there anything additional, Ms. Spear, Mr. Haddad?
No, Judge.
No,
All right.
Judge.
Best of luck to you, Ms. Rogers. That concludes your case. Let me sound for Ms. Collins. Is Ms. Collins present? All right, hearing none. Best of luck to you. This matter is closed.
Just to confirm, this was 13 days, correct?
I'm sorry, say that again.
This was 13 days, correct?
The sentence was, I had 7, but I guess she's been in there longer than that.
Oh, I
So
thought
what?
Mr. had said something, was clarifying today, so I was trying to clarify that. I apologize.
Either way,
No.
Judge, 7 days is fine.
7, okay.
I just don't know however many times served. All right. Who do we have next?
Position 48 and 49, Miss Shanta Stanford.
And Your Honor, on that position, Ms. Stanford, that should be fairly straightforward. She missed court April 20th of this year, but she's been in custody here in Fulton County since January. on some other charges. So that's why she did not appear in court on the 20th. This was a citation, is what I suspect initially.
So this is, what are we doing today though, Mr. Haddad? What's the announcement?
I'm basically asking to set aside the bench warrant and release her on her own recognizance, Judge.
So we're asking for essentially another bond hearing. Okay, Ms. Stanford, your case is 26 CR 0000359. I'm sorry, 0359J. Your charge was battery, so I don't think this is maybe not a citation, Mr. Haddad. Reckless conduct, 2 counts, dog at large, failure to quarantine, interference with an animal control officer, no proof of rabies vaccination, and no Fulton County tag. There's also an FTA. Ms. Dahlworth, can I have the history for position 48 and 49, please?
Yes, Your Honor. She has 3 cycles total. There's an active warrant. I guess it's for this FTA because it's April the 20th of 2026. There's an open case 26 SC 000229 for aggravated stalking, disorderly conduct, and willful obstruction of law enforcement officers. She's currently on probation for case number 26 CR 001261Y, reckless driving, hit and run, and driving while license suspended or revoked. Also on probation for case number 26 CR 000103Y for loitering, prowl, and willful obstruction of law enforcement officers. Nothing further.
Okay, so in this particular case, we have the same situation. Did she make, she's already made bond on 48. What is the current amount of the FTA hold?
You know, it is 1,000 on the FDA.
$1,000 FTA. Okay, Ms. Spear?
Based on her history, the open cases, the amount of probation that she's on, and taking into consideration the charges and the current case, state feels that $1,000 is awfully generous and would ask that it remain.
And if I may, I mean, the issue is there's no failure to appear since she was in custody. So, I mean, that's really the issue. It has nothing to do. I mean, she was arrested in January. She resolved both of the cases that pretrial mentioned. She did not appear in court April 20th is because she was in custody in Fulton County. So,
oh, she was in the Fulton County Jail when this?
She's been in custody since January 11th of 2026, Judge. So when court was issued for her for April.
And nobody, that's only reason that's usually we catch those, Mr. Haddad, when the person, like the division judge usually pulls that right up and they'll see the person is in custody in the jail. Hold on, let me look. And what did she miss? What court did she miss?
I mean, she missed April 20th is the court date that she.
What was it? Do we know?
Arraignments, plea and arraignments. Now, the accusation is her first name is Shanta, but she was booked. I mean, same information, but the first name is slightly different, Judge.
And she's currently still, is this the only case holding her in?
That is, yes, because she resolved the other 2 cases that she was initially arrested for, in fact, January.
I'm just trying to figure out how this happened, if it did happen as we indicated, because I mean, usually when you plea and arraignment happens, the first thing we do is get that screening of jail and who's in jail. Let me look, hold on.
It looks like Mr. Haddad might actually be correct on this.
I believe it. I'm not saying Mr. Haddad is lying. It's just I'm trying to figure out how we got here. That feels.
Oh yeah, no, I'm with
it
you on
feels
that
really
one.
wrong, and I'm trying to figure out how we avoid this. And okay. And she has she's going to be able to update her address, Mr. Haddad, so upon her release, this doesn't happen again.
Yes, Judge. I mean, she has to report to probation anyway for the other two cases that she resolved.
Okay. All right. So I don't want to send her through pretrial, and because of the charges, Mr. Haddad, she cannot just get a signature bond.
But
She's gonna receive $1 cash bond,
Your Honor,
and yes,
if I may, I mean, the failure to appear should have never been issued.
I
period.
know, but what
That
can I do?
failure to appear has to be dismissed. And if it is dismissed, then she is released. I mean, there's no way around it. We can't.
I know they're you know what position I'm in. You know what the let me look. Hold on. Let me look up one thing. Okay. We'll do it. What we do is if this was on the DV bench warrant calendar, I'll do the revocation, or I guess the set aside of the FTA in light of the fact that she was in the Fulton County Jail at that time. All right. So I will set aside. Mr. Haddad, can you still submit a proposed order for that to set aside the FTA?
I'll take care of that, Judge. And is Ms. Strong who I need to send the paperwork to?
Yes, please.
Yes, sir.
All right.
All right. Best of luck to you, ma'am.
Thank you. What does that mean?
Position 54, Miss Megan Williams.
That's going to be a not guilty, Judge.
Okay, so we're gonna reset that case to the division.
Yes, Judge.
All right, Ms. Williams, your case is 25 CR 001875F. You're charged with theft by shoplifting in this case. Your attorney has indicated that he wishes to do some additional development, so your case will be reset to a later date for trial, okay?
I want to say stop looking for what case is that? I don't know what case is it.
This is a theft by shoplifting case that took place in April of 2025, Ms. Williams. Okay? Your attorney, somebody will speak with you between now and that trial to help you get prepared, okay?
Thank you, Judge.
I want to say like this.
Listen, she already made her ruling.
And I don't want you to say too much, okay? Your attorney has looked at the case and has decided it's best for you to proceed to trial, okay? They're operating in your best interest today. Somebody will come talk to you about this case, okay?
Okay, so I want to say if it got something to do with that, I'm going.
I don't want you don't say something that the state is going to use against you, Miss Williams, okay? They are listening. You might say something by mistake that you don't think is going to hurt you, but it might end up hurting you, okay? Just wait for your attorney to give you a call, okay?
Okay, I appreciate it.
Yes, ma'am. Take care and have a good day, all right?
Thank
Are
you.
you welcome, please? Take care. Bye-bye. Bye-bye, Milton. Bye-bye.
Listen, please don't sign off, Judge. Could you please answer your phone right quick?
Okay.
I have to give you a call, Milton. Don't sign off.
Somebody's still in the jail that shouldn't be. Somebody's lost? Is that what's wrong?
No, that's not what's wrong.
Okay.
It's
That's
about
usually what happens in ACDC. Somebody's lost.
No. It's about Miss Stanford.
Okay.
Okay. I'm calling you now.
Okay, bye-bye. Mr. Haddad. Mr. Haddad, can you come back for a second?
Yes, Judge.
Okay, so the case we just did, Miss Young informed me procedurally I can't do what I can't set aside the bench warrant because the minute she was rearrested, the bench warrant gets set aside. So she is in there as if she has $1,000 surety bond, and I can't just set it aside, and I can't turn it into a signature bond through the jail because of the nature of the charges, even though I do understand the totality of the situation. So either the options are a dollar cash bond, Mr. Haddad, or a signature bond through pretrial services at level 1. I'm inclined to give her the dollar cash bond so she doesn't have to do those requirements, but as her attorney, I'll let you advocate for her.
I mean,
I get it, but I mean, the problem is it would almost have been better if it was calendared as a set aside calendar, but she currently has $1,000 surety bond that we have to deal with.
Judge, for the time being, just $1 amount, something like that. I will say, Judge, and I understand I mean, if it was wrongly issued, which it was, then there's really no legal basis to do any.
I get it, but the problem is she's in there being held on a bond that we have to do something with, and that bill that we have.
I would ask for $1.
You would rather do the dollar, or you want her to go through pretrial?
I mean, I would hope somebody can pay $1.
Okay, what we're gonna do is we're gonna give her.
I'll pay $1.
Oh, you're gonna give her $1? Okay, so we'll make it a dollar cash bond, and we will take care of it that way. And if for some reason she can't get the dollar, let's reset her to Tuesday, and then we can consider the pretrial.
Judge,
Your Honor, my apologies. I mean, you can do a dismissal on the FTA and then she can just handle the other case. But the set aside is not what we can do. Yeah, I mean, you could dismiss.
I mean, but a dismissal, but she's still gonna have, that doesn't quite.
She'll still handle the other case, but she won't.
No, I get that part, but you can't really, the way, if you look it up, you can't really dismiss a FTA because once a bond is set on it, it has. Okay, let me look. I've been looking at this all day.
Judge, Mr. Jordan said, hold tight for a second.
What's the case?
Hold on 1 second, Judge.
Okay. Well, she's gonna get out, Mr. Dow. We're gonna figure out the best way to do that. It almost, if the best thing would have been is if these kind of get put on a set aside calendar when they first get put in. Okay, let's come back to that. Let's keep going. We'll be here all through lunch if we don't keep going. Can we do another position while we look at this?
We can. Number 19, Mr. Hope.
Judge, that's gonna be a sheet of plea, Your Honor.
Thank you. Okay. Uh-oh, I lost my calendar. That's not good. Give me 1 second. And this is Mr. Hope?
That's correct.
Okay, thank you. All right, good morning, Mr. Hope. Your case is 26 CR 002923L. You're charged with criminal trespass and possession and use of a drug-related object. Do you understand your rights?
Yes, ma'am.
All right, thank you. Ms. Spear?
On count 1, criminal trespass, state's recommending 12 months probation, excuse me. Serve 10 days, which I believe is the amount that he served. It might be more, because this is from last week. 40 hours community service. Stay away from the Polaris Apartments at 3072 Washington Road in East Point. On count 2, 12 months probation, credit for time served, and an ADET.
All right, that was your understanding, Mr. White. You so stipulate to the 3 elements?
Yes, Your Honor. To both questions. We would ask for a waiver of any waiver of fees that the court could give us on probation and allows probation to terminate or go non-reporting once he completes it.
All right, I will waive 1 month and then it can go non-reporting. All right, Mr. Hope, please raise your right hand if you wish to take a plea. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
I know.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No.
Did anyone promise you anything in exchange for taking a plea today?
No.
Did anyone force you to take a plea? Do you understand that you're giving up your right to trial by judge or jury? And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? And you fully understand the requirements, including the community service you need to complete, and that you need to stay away from the location on Washington Road? And that you're also going to undergo some evaluations?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life that your attorney or I may not be able to anticipate, such as employment, probation, immigration?
Yes, ma'am.
And you're satisfied with Mr. White's representation?
Yes.
All right, as to the charges of criminal trespass and possession and use of drug-related objects, how do you plead?
Yes.
I accept your guilty plea. Is there anything additional from State of Defense?
No, Your Honor.
Yeah, Your Honor.
All right, best of luck to you, Mr. Hoke.
All right. All right, next we got position.
Oh, okay.
22, Mr. Johnson. Perry Johnson.
All right, Mr. Johnson, your case is 26 CR 002960D. You're charged with loitering and prowling. Do you understand your rights?
Yes.
All right, thank you. What's the announcement, Mr. White?
It's negotiated plea, Judge.
Thank you. Ms. Spear?
State's recommending 12 months probation, 16 days to serve, which I believe will be credit for time served. I show 8 days. MHET, stay away from 2868 Andrews Drive, Atlanta.
All right, thank you. Mr. White, do you so stipulate and that was your understanding?
That is correct, Judge. Same announcement, same request, to waive a month probation fees and allow probation to terminate once he completes his evaluation.
All right, I will waive 1 month. All right, Mr. Johnson, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange?
No.
You satisfied with Mr. White's representation?
Yes.
And you understand that you're going to undergo an evaluation and stay away from the address on Andrews Drive?
Yes.
And you understand that taking a guilty plea today, you're giving up your right to a trial by judge or jury?
Yes.
All right, as to the charge of loitering and prowling, how do you plead, Mr. Johnson?
Please.
How do you plead?
If you want to accept it. Yes.
I accept your guilty plea at this time. Is there anything additional from State or Defense?
No, Your Honor.
All right, best of luck to you, sir.
Going back to number 1, Mr. Bakers.
All right, so have both sides had the opportunity to review the notes from Judge Lawler as documented last week, and are we going to go forward with the plea today?
And Judge, as far as I'm concerned, with the time element especially, we would be in favor of that. Everything else, I guess, would remain the same. The 2 years of probation, adding the interlock device to it, 2 meetings per week. I would ask they not necessarily be AA meetings, but some sort of, or something similar.
What about the monthly screens?
We can, yes, we 2 screens.
I saw
Okay.
that the recommendation was 3 visits for 6 months minimum for AA. Is what Judge Law wrote.
Those were the notes. Let me go back.
I'm sorry, I may have missed that.
So and it's unclear to me what really if it was something that was said, like this was what she was indicating. But my question is, as written and as sent to both parties, is that something that we can agree to today? And does your client wish to take the plea as I guess ordered by Judge Law last week?
And the AA clarification, I'm sorry, Ms. Spear, what was that?
It's 12 months and enrollment in AA program, a minimum of 6 months with 3 visits per week.
Okay. And like I said, we would request AA or something similar, because there is a constitutional issue with the requirement to be AA.
Right. But I think it's not so much the program itself, but the frequency of it, the 3 visits a week. Does he have an issue with the 3 visits a week?
No, Judge, we're good with that.
And can we
Okay.
just ensure that it's, I mean, the essence is going to be the alcohol relation. So, I just
We
want to
can
be
call
clear
it,
that,
we can call it an alcohol program, but I do agree there are
Okay.
other equivalents that could meet the
absolutely. I
requirements.
just don't want to be confused, like he shows up for anger management or something. So just as long as we're clear that it's an alcohol program.
I don't think that, I think the essence here is we're all trying to get him into an alcohol type program. Okay, I'm gonna forward, I should have sent that to Ms. Strong. Ms. Strong, I'm gonna copy this to you if I
Thank
can
you.
figure this out. And then will you please put it onto the record for me, Ms. Spear, the negotiated
absolutely.
offer as ordered by
Um,
Judge Long?
The DUI per se, count 1, 12 months probation, serve 40 days, credit for 20 days already served, balance probated, ADET, risk reduction, a $750 fine, 240 hours of community service, 1 VIP victim impact panel, plus mandatory and random screens for illegal drug use and alcohol use, an ignition interlock device for 12 months, enrollment in an alcohol like program like AA for a minimum of 6 months with 3 visits per week. DUI less safe will merge. Driving while license suspended or revoked is 12 months probation, serve 26 days with credit for 13 days already served, balance probated, $1,000 fine consecutive to count 1. Absolutely no driving unless he produces a valid Class C license, current insurance card, and current registration. Insurance and registration must match. Failure to obey a traffic control device, which is count 4. 12 months probation, served 26 days with credit for 13 days served, balance probated, concurrent to count 1. Also, no alcohol or illegal drugs for the next 2 years. Probation cannot go non-reporting.
All right, those were quite a few requirements. Mr. White, does your client wish to take this plea today at this time?
So, we would ask for, considering the heft of fines and all the community service he has, we'd ask for at least 3 months of waivers of probation.
All right, I will waive 3 months of fees. He's saying your client does wish to take the plea today?
That's correct, Judge.
All right, Mr. Baker, I'm gonna take the plea. Oh, I close. This is really hard when this is not printed. Give me 1 second. Give me 1 second, Mr. Baker. All right, Mr. Baker, just put your case number back onto the record, 26 CR 002800E. In this case, you're charged with DUI per se, DUI driving under the influence of alcohol, driving with license suspended, and failure to obey control signs. Please raise your right hand if you wish to take a plea. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
Are you satisfied with Mr. White's representation?
I am.
And you understand that by taking a guilty plea today, you're giving up your right to trial by judge or jury?
Yes, I do.
And you understand that taking a guilty plea can affect other aspects of your life, including employment, probation, immigration, other open cases or matters I may not be able to anticipate, nor may your attorney?
I do.
All right, and you are satisfied that Mr. White has fully informed you of all the requirements and you understand them as just indicated by the state on the record?
Yes, ma'am.
All right, as to the charges in the case ending in 2800E, Mr. Baker, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from the state of the defense?
No,
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 Your
Your
Honor.
All right, best of luck to you, sir. That concludes your case.
thank you.
Thank you, Judge.
Thank you.
All right, next we got position 33, 34, Mr. Orr.
Okay, Mr. Orr, your case is 25 CR 004743F. You're charged with DUI, seatbelt violation, failure to maintain insurance, HOV violation, speeding, reckless driving, knowingly driving on a canceled registration, driving while the license was suspended, and possession of open container. What is your announcement, Mr. White?
Judge, we had him as released and just now realized he was here. So I'll go over the whole and we'll get back to you in a minute, okay?
Oh, okay. Well, you do understand your rights today, Mr. Orr?
Yes.
Okay, we'll stick with that and then we'll go back. All right, we'll come back to this matter.
Go to 35 to 37, Mr. Parker.
Who represents Mr. Parker?
Your Honor, that's a conflict case, Judge.
Oh, does anybody know if Miss McLeod is coming?
I believe Ms. McLeod is out this week, I think.
Oh, yeah, she did file
A conflict.
a leave. Yeah.
Your Honor, she's out to June the 8th.
I'm sorry, say that again?
She's out until June 8th.
That's not good. Can we see if Mr. Murphy can help him? Did Mr. McLeod previously represent him? Because these are time served off. One offer he would have to, are these time served? I don't want to reset him to June 8th, of course. Ms. Spear, the offers,
No, it's
he
not
would have
covered by
additional
time served.
time.
Yeah.
He would have additional time. Okay, Mr. Parker, the offers on the table for you right now would not release you from Fulton County Jail. So I am going to reset you till next week's calendar. And I understand Ms. McLeod will be out. Can we see if Mr. Murphy or another conflict attorney might be able to assist Mr. Parker? In the meantime, can we send that email? And then we'll reset SAP next week. All right, so Mr. Parker, we will see you next week. Someone will speak with you between now and then. All right, yes, you have a question? You currently have a bond. So if somebody bonds you out, if you're asking for a reduction of the bond, we'll make sure that a conflict attorney speaks with you, okay?
Number 42, 43, Mr. Rembert.
I'm sorry, give me 1 second. I'm sorry, number 43.
42 and 43.
42 and 43.
42 is his FDA.
Okay. Who represents Mr. Rembert?
That'll be me, Judge, and it's gonna be a negotiated plea. It's a time served sentence essentially, Judge.
Okay. All right, Mr. Rembert, your primary case is 25 CR 001418E. In that case, you were charged with fleeing and attempting to elude, driving without a license, obstruction, and criminal trespass. You also have an FTA. Ms. Spear?
Yes, we've agreed to dismiss the case, FTA case, position 42 with a plea to position 43, case ending 1418E. In that matter, the state's recommending on count 1, fleeing and eluding, 12 months probation, serve 46 days, which is credit for time served, and a $500 fine. Driving without a license, this is his 4th in life, so we are asking for a $1,000 fine. Obstruction, we're asking for a $300 fine as required by statute, and for the criminal trespass, 12 months probation to run concurrent and to stay away from the Washington Food Mart at 3887 Washington Road.
Okay. Mr. Haddad, do you so stipulate to the three elements, and was that your understanding of the agreement in this case?
Yes, Judge, we stipulate, and that is our understanding. Mr. Rember has served a total of 55 days, 9 days this time around, and initially when he first got arrested, 46 days, Judge.
All right, thank you. All right, Mr. Rember, please raise your right hand if you wish to take a plea. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea? No. And you understand you're giving up your right to trial by judge or by jury?
Yeah.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yeah.
And you fully understand the requirements of the sentence as explained to you by your attorney and just put onto the record by the state?
Yeah, ma'am.
And you understand that taking a guilty plea may affect aspects of your life, such as employment, probation, or other matters that I may not be able to anticipate at this time.
Yes.
All right. As to the charges as I just read in the case ending in 1418E, Mr. Rembert, how do you plead?
Yeah.
I accept your guilty plea. Make sure you stay away from that location. All right. Best of luck to you. The matter is now closed at this time.
Thank you, Judge.
Number 44, Mr. Rhymes.
All right. And the announcement for that case?
Mr. Rhymes wants the bond hearing, Judge. We're requesting pre-trial release to pre-trial services.
Okay. All right, Mr. Rhymes, your case is 26 CR 002936A. You're charged with simple battery and simple assault. Ms. Stallworth, may I please have Mr. Rhymes' history, position 44?
One moment, Your Honor. He has 25 cycles total. There's an FTA in 2024 out of Fulton. There's a 09 first offender out of Fulton for forgery first degree. There's a 04 conviction out of Fulton for giving false name. And an FTA in 04 out of Fulton. There is an 01 simple battery out of Fulton. There's a 04 out of Fulton for simple battery. And there's a 1994 out of Fulton for battery, simple battery, and willful obstruction. There's a 91 theft by shoplifting from the city of Atlanta. Nothing further to report.
Thank you. Ms. Spear?
I was also looking at his history, Your Honor. Just 1 minute. It looks like, yeah, the only concern would be the FTA from 2024, it looks like, especially in light of the fact that it's a battery and he's currently facing simple battery and simple assault. So we would ask that it remain as it is.
What's his current bond?
3,500, Judge.
Can I add something? My apologies. There is an open 26 PI case 003666 for ag assault and battery family violence, first offense.
That's open?
Yes, Judge. And that
Yes, Your
case,
Honor.
he's got a $15,000 bond on that case on the felony charge, and with a preliminary hearing scheduled for June 1st. Mr. Rhymes, when I talked to Mr. Rhymes, he wishes to get a signature bond on this case, as he anticipates he'll be able to post bonds on the felony charge, hopefully. It's a different fact pattern, as a different victim, different alleged victim, Judge. Mr. Rams is 56 years of age, relates to me, and he's been in custody since the date of arrest, which is 15 days ago. And would you stop a second? He does describe a host of medical issues that he has, including congestive heart failure, I think diabetes and high blood pressure, Judge. Under the circumstances, I would just ask the court to consider granting him a signature bond through pretrial services, understanding that he's not going to be released right away. There's also indication that the alleged victim in this case gave a false name. I'm not really sure there's a Dolores King.
Your
That's
Honor,
all.
we just have concerns about the amount of violence going on. There's also a gun alleged to have been involved in this. He's not charged with pointing a weapon at her, but the allegations are that he did pull a handgun and waved it around. So based on the open ag assault, the history of the FTA, the violence that's involved in his history, we think this is more than generous as is.
I need to look at one thing. But to be honest, Mr. Haddad, I'm not hearing much to justify an adjustment to the bond. But I'm gonna look up one thing.
Yeah, how's that? So.
The offer, if he had taken the offer today, he would have gotten out but had to do FVIP
And 40 hours of community service. Yeah.
service. What are the current bond conditions? Not just the amount of the bond? Was it, so I know Judge Law often does FVIP. Was that one of the bond conditions? Let me look it up.
Yeah, I'm trying to find it.
I know Odyssey is moving so slow. I was hoping somebody had it faster than me.
You and me both.
Uh-huh. All right. I can't find the conditions. Ms. Young or Ms. Strong, can you tell me what the current conditions are for this bond? It keeps circling and circling when I'm trying to open it.
We're having internet problems here as well, Judge.
It might be Odyssey
It might be
itself.
Odyssey.
Right, because it's just circling. I can't see what the bond is.
1 second, Judge.
Thank you. Hopefully yours works, Ms. Strong.
I think I haven't been strong, even though my thing keeps going down. It's 3,500.
Good.
And the conditions are no drugs, no weapons, no alcohol. Stay away from no further contact with Dolores King. Stay away from 2386 Herring Road Southwest and victim's residence.
But she didn't have any classes or anything on it. Okay. I will reduce his bond slightly. He's not gonna get a signature bond. In light of the time he has served. It'll be a 2,000 good with those same conditions.
All right, I'll prepare the order, Judge.
All right. Best of luck to you, sir. What do we have next?
So what day are we resetting him to, Your Honor?
I guess in light of the open case, Mr. Haddad, do you want him to go division? Do you want to enter the waive? Or do you want him to come back to SAP? Is he likely to take a plea in this case next week or another day?
We'll waive, Judge.
All right. So I think that's the best course of action anyway. All right. We're going to send him to a division.
We're not picking the guilty. You've been telling me all along you're not guilty, so we're not doing it.
So 33, 34, Mr. Orr, again.
What is the announcement?
Judge, I'm not sure yet. Like I said, we have Mr. Orr as released and I have no information whatsoever. I did look at the FTA that he's here for on the DUI and it looks like that was issued on the 14th of May. And I believe he was in jail. So, I mean, he's here. He's been here, yeah, he was, as of the 15th, he had been here 2 days. So he was, we're just not sure what happened. And
I am mystified because this doesn't usually happen. Let me look.
Judge, it happens quite a bit.
Not to me. It does not happen to me.
There are a lot of
just
division judges that, you know, they
every time I sit division, we run it through and we check to see if the person is not if the person is in the Fulton County Jail. Okay, that is the first place I personally check.
But I don't know if the court of the state can provide more. I mean, now it just says the offense date for the FDA is 5/14, so I assume that's the date he missed court. But so
let's see. Does anybody know what he missed?
1 second, Judge, I'm looking.
I show May 4th, I think, is what I just saw.
It is May the 4th.
May 4th.
Calendars, okay.
Yeah, I don't know why it says the 14th. Maybe it's a typo, but it was the 4th.
And was he in the Fulton County Jail then or no?
Not on this chart. There was another chart. So
okay, let's see if I can get the bookings to open. Was he in jail on that? Okay.
I don't show anything.
I don't either. I don't see that he was here. And
booking number, that's not necessarily going to show, right? I mean, it would be.
It doesn't, but I'm just trying to find something to show. You're saying he was in jail on the 4th?
I'm sorry, his booking number is 260-8387. Look up under that booking number, and that gives his information. But it doesn't show that he was.
Judge, I'm not saying that he was. I'm saying I don't know. I do know there was another charge though.
260-8387. Thank you.
You're welcome.
Oh, this is impossibly slow. I need somebody else to try this. Okay, so he probably was not in jail, Mr. White, is what I'm saying. But I'm gonna keep looking. In light of that, and you say you just spoke with him, are you asking for a reset? I'm assuming he's rejecting the plea offer that's on the table today.
Well, I couldn't really advise him until I knew a little more what was going on. I mean, if he had a legitimate excuse for not being here in court, then I was going to advise him to get the bench warrant set aside. Obviously, plead not guilty. So we're saying we don't think he was in jail on.
I don't see any indication he was in jail on the 4th.
No, he wasn't booked in until the 14th.
Right. I'm not seeing any. He missed. There's the FDA appears to be valid.
And you said he went to court. Okay.
I think. Why don't you mute us for a second, Mr. White?
Yeah. Judge, we're just going to enter a waiver.
Okay, so we'll reset division. Mr. Orr, your attorney is going to do some additional development on this matter, okay?
Okay. Thank you, Judge. You have a question for me? Oh, you can't have. All right, thank you, Judge.
Thank you.
Let's get 46, 47, Mr. Smith.
Like I said, it happens. Sometimes there's 2 different booking numbers, and that's what happens.
Okay. Let's see, Mr. Smith, your case is 26 CR 00 2644C, you're charged with criminal trespass, and you also have 26 CR 0022, I'm sorry, 2770C, and in that case, you're also charged with criminal trespass. Do you understand your rights today?
Yes, Your Honor.
All right, and the announcement, Mr. Haddad?
That's gonna be a negotiated plea. I believe it's a time served sentence. We tried to, he was on the calendar last week, but he was taken to Grady, Judge. So, it's time served with a stay away from the Whistler apartments. So negotiated plea.
All right, thank you. Ms. Spear?
Yes, Mr. Haddad is correct. They're both criminal trespass at the Whistler Apartments. So we are simply asking 12 months probation, credit for the time spent in jail. I show 2 days. It's probably more than that. It may be more than that, I guess. And to stay away from said Whistler Apartments at 859 Spring Street for both counts.
All right, and you so stipulate, Mr. Haddad, and that was your understanding?
We stipulate, and it is our understanding, Judge.
All right, thank you. All right, Mrs. Smith, please raise your right hand if you wish to take a plea. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, Your Honor.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, man.
Did anyone force you to take a plea?
Nah.
Is that a no?
No, Your Honor.
All right, good. And you understand that by taking a plea, you're giving up your right to a trial by judge or jury?
Yes, Your Honor.
All right, and you understand the requirements that you cannot go back to that location?
Yes, Your Honor.
And you're satisfied with Mr. Haddad's representation of you?
I'm satisfied with every one of you guys. I'm happy.
Okay. All right, and you understand that you are taking the plea today and that may affect other aspects of your life?
Yes, Your Honor.
All right, as to the charges of criminal trespasses in the 2 cases I named, Mr. Smith, how do you plead?
Not guilty.
Not, you plead not guilty? You want to go to trial?
No, Your Honor. I'm sorry. I'm sorry.
So answer the question. Do you want to plead guilty or not?
Do you want to plead guilty or do you wish to go to trial? Remember, pleas are voluntary, so I have to be sure that this is what you want to do.
I plead guilty.
And you're sure that's what you wish to do at this time, Mr. Smith?
Yes, Your Honor.
All right, I accept your guilty plea. Is there anything additional, Mr. Spear? Or, I'm sorry, Ms. Spear, my apologies, or Mr. Haddad?
Nothing further. Thank you.
Nothing further, Judge. Thank you.
All right. Best of luck to you, sir. That concludes your case.
Thank you.
Thank you, love. You guys have a good night.
All right. Take care.
Thank you.
That's condition number 50. That's gonna be negotiated plea, Judge.
All right. Thank you so much. Let's go to Mr. Tarver. Your case is 26 CR 002954A. You're charged with criminal trespass and 2 counts of theft by taking. Do you understand your rights today?
No, yes, ma'am.
Thank you. Ms. Spear?
Okay. On count 1, criminal trespass, state's recommending 12 months probation, credit for time served of 8 days. Stay away from the Georgia Tech campus in its entirety, all buildings associated therewith. On the count 2, theft by taking, state recommends restitution of the bike to victim Stephen Aiello. I believe it's estimated at $1,100. On count 3, theft by taking, state recommends restitution of the e-scooter to victim Ryan, R-Y-O-N Deep. I can't remember the estimation of value on that. But we can set it for a restitution hearing for exact dollar amounts if defense wishes.
All right. Is that what you wish, Mr. Haddad? And do you so stipulate?
Yes, we stipulate, Judge. We'd ask for a hearing within 30 days, Judge.
Okay. All right. All right, Mr. Tarver, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Ma'am, yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to take a plea today or to understand what's happening?
No, ma'am.
Are you satisfied with Mr. Haddad's representation?
Yes, ma'am.
Did anyone force you to take a plea or promise you anything in exchange?
He said no, Judge.
Oh,
No,
you
ma'am.
said no. You said no. Okay, thank you so much. It wasn't clear. I appreciate that. Do you understand the requirements as explained to you by your attorney that you cannot go back to Georgia Tech and you're going to be required to pay some restitution? Do you understand that?
Ma'am, yes, ma'am.
All right. And you understand that today you're giving up your right to a trial by judge or jury,
Ma'am, yes, ma'am.
and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Ma'am, yes, ma'am.
And you fully understand that taking a guilty plea can affect other aspects of your life, such as any other open cases, probation, immigration, other matters we may not be able to anticipate. Do you understand that?
Yeah, ma'am, yes, ma'am.
As to the charges of theft by taking 2 counts and criminal trespass, how do you plead, Mr. Tarver?
Guilty, ma'am.
I accept your guilty plea at this time. Is there anything additional, Ms. Spear or Mr. Haddad?
No, Judge.
All right, Mr. Tarver, best of luck to you.
I'm sorry, Judge, Miss Spirit, when I asked you that question, I meant the conditions. What is, I
Okay.
mean, for 50? I apologize, Judge.
Stay away from Georgia Tech campus and all buildings, and the restitution to Stephen Aiello and Ryan Deep. Do you want me to put their names in the chat?
No, I have that, but what is it? It's so the 2 theft by takings is just 12 months to pay the restitution? What happened with the theft by takings? That's what I'm asking. I must have missed
Yes,
that.
it's just restitution to both victims. We're going to have a hearing on the exact amount within 30 days.
Okay, thank you.
Mm-hmm.
Thank you, Judge.
Thank you.
All right. Are we ready for another position?
You think we're done, Judge?
Okay, before we, I still had some that said we needed to speak to. What about, let me look really quickly. I know some say reset SAP next week, don't bring. I did have a question about, let me look, Mr. Pitts.
No, that's gonna be a not guilty waive.
Okay. And number 32, I didn't have any, I think I had needed to speak to that person too.
Judge, Mr. Murray was not brought,
Was, but he had the misdemeanor later.
okay. We're gonna have to reset him, Judge, next
What
week.
happened to, he's a medical reset?
I think behavioral judge.
He said that he worked last at a trustee. He was here. He said he held the misdemeanor later. We have a question.
Judge, we'll hold on just a second, Judge. I'm sorry, let me. Yeah, we're gonna waive Judge, plead him not guilty. He's got another matter of probation hold.
Okay. Okay, and then number 15, Mr. Dupuy.
15 GP.
Oh, that's gonna be. Yeah, that's the waiver, Judge.
Okay. And 55 and 56, that's a waiver as well?
Yes, Judge, she was brought in front of you. That was Megan Williams, Judge.
It was, let me see. Okay, she had more than one case.
Yes.
Oh, did I miss that? Let me see. Okay. Okay. All right, I think we are complete. Now, back to Miss Stafford. So I guess what we're gonna do is I'm gonna dismiss the FTA. Is that procedurally what we can do? Because I'm reading conflicting things.
According to Mr. Jordan, Judge, you can, but he said he was gonna contact you.
Okay. Because once it gets set aside and the bond attaches, something typically has to happen to the bond. It's not a I guess yeah.
Well, I mean, really the issue, Judge, is that
She shouldn't have got, the issue is she shouldn't have gotten an FTA. That's the real issue. So, but the problem is once the jail saw it, they set it aside and turned it into a bond. And that's the only thing is I'm trying to make sure that whatever we do will actually get her out of jail and not turn into a thing where she ends up sitting there.
Well, I mean, the short answer is a dismissal of the failure to appear because it was issued incorrectly.
Right. And I mean, I agree with you, but what I'm saying is sometimes the things that I think are really easy to do turn into something that's not. And I get lots of emails later when I'm no longer working and the person is still sitting there. So that's what we want to avoid.
Hey, good morning, Judge.
Good morning, Mr. Jordan.
So you can just dismiss the FTA hold. Just do a dismissal order for the FTA warrant, and then that'll take that hold off her jail screen.
Okay. Mr. Dodd, can you at least send that over to Ms. Strong?
Sure.
If you'll come up with something. Okay, can we review the calendar, please?
Position number 1 was a plea. Position number 2 is being reset further notice. Position number 3 was given a $2,500 signature bond through pretrial. Position number 4 is reset for June the 4th. Position number 5 and 6 are released. Position 7 and 8 are reset for June the 9th. 9 was a plea. 10 was non-pros. 11 was a plea. 12 is reset for June the 2nd, SAP. 13 and 14 were a plea. 15 waived arraignment. 16 is being reset for June the 9th, SAP. 17 was given an amended bond of $5,000 surety. 18 was waived arraignment. 19 was a plea. 20 and 21 are being reset for June the 4th. 22 is a plea. 23 waived arraignment. 24 and 25 and 26 were released. 27 and 28 were released. 29 and 30 are being reset for June the 2nd SAP calendar, as well as position number 31. Position number 32 and 33 and 34 waived arraignment. 35 and 36 and 37 are being reset for next Thursday, May the 28th SAP calendar. 39 through 41 waived arraignment. 42 non-pros. 43 was a plea. 44 was an amended bond of $2,000 surety. 45 and 46 were a plea, as well as position number 47. Position 48 is being reset for further notice. 49 is dismissed. I apologize. 50 is a plea. 51 is being reset for next Thursday's SAP calendar, May 28th, as well as position 52 and 53, 54, 55, and 56 waived arraignment.
Uh-oh. Any comments, changes, corrections, questions, or otherwise?
All
right.
I have a question, Judge. On position number 11, did you waive fees on this position, or was it just probation and suspended upon completion?
Let me go look.
You can come back. You can just let me know. I just wanted to ask you now. You can follow back up in a minute.
I'm gonna have to. I have no idea. Let me look. Hold on.
According to my notes, Your Honor, and Ms. Strong, it was just a no-low plea. But when she been saying waived, I wrote that down, but I didn't. So we might want to check with Mr. White.
No, she said something was suspended upon completion because he had to do the $500. He had a $500 fine that was the community converted to community service.
And he took a no-low plea. I didn't write waiver.
Okay, I just wanted to, I didn't have it either, but I just wanted to make sure.
Yeah, I don't think there's a way. Mr. Bartels, are you taking any pleas at the 11 o'clock calendar?
Yeah, good morning, Your Honor. There's a possibility we may have one plea. I just wanted to let everybody know that. Ms. Spear, are you handling that calendar?
No, Ms. Tucker will be logging in momentarily.
It's like, okay, I sent an email to Ms. Tucker. I neglected to do that until this morning. But I'm just waiting to hear back on the plea offer. So we may have one plea at 11.
Okay, thank you for that. With that, Ms. Mann, if you would just remain with us just a little longer so we can take that plea. And who is handling, Mr. White, are you gonna do our DV reset?
I'll take care of it, Judge.
Okay, we're a few minutes early. I don't see that anybody for that calendar has logged in.
One of the people on the calendar does have private text.
Okay, understood.
Mr. Bartels, it does appear that Ms. Tucker just responded to you via email.
Okay, I'll check it. Thank you.
Okay, so we're gonna be on hold for a second.
Judge Williams, do you mind if I step off for just a second? I need to go grab
Yes.
some. The printer.
Yes,
Thank you.
we're all gonna take an 8-minute break. We'll return right at 11 o'clock. Thank you all.
Thank you.
Yeah. So they're both gone.
All right, we are ready to commence our DV bench warrant calendar. There are some parties that Mr. White, you indicated have a private attorney.
There is a private attorney for one of the cases.
You know which one?
Position number two, Judge. It's
Okay.
position two, Judge. Yeah.
Dominique Golden position.
Okay, I saw Ms. Golden. So, Mr. White, are you able to speak to Mr. Caballero?
I can, if he, Ms. Caballero, can you take down a phone number? First of all, do you speak English?
Yes, sir.
Okay, perfect. All right. I'll make sure. Can you
Can
call?
you, I don't want you to give everybody your number, Mr. White. Is there a,
No, I'm
I'm
gonna.
gonna give him the jail number.
Jail
Okay. Understood.
612 2932. Let me double check.
And Ms. Golden, you have a private attorney. Is your attorney logging on to assist you today?
I don't see him on here, but I'm texting him now.
Okay, I think you should reach out to him.
Okay,
I'm sorry,
thank
the last four, it's 404 612 2392.
And is there a Victor Robinson also on the line?
No, Your Honor. Am I putting Mr. White and Mr.?
They're gonna call.
Oh, they're gonna call. Okay. I'm sorry. I just came back to my desk. My apologies.
That's fine. Thank you,
Actually,
Ms. Young, for checking.
That may be easier. That doesn't hurt. If it's not a problem for you guys, you could throw us in a break.
Okay, you can put them in a breakout. That's fine.
Yes,
And,
ma'am.
and hopefully, Ms. Golden, you'll get your attorney on the line. Otherwise, we will likely have to reset
you.
you.
He said that he's logging on right now.
Okay.
Thank you.
Okay, so if Mr. Robinson isn't here in the next few minutes, that FTA for him will stand.
I can reach out, Your Honor. I'll give him a call.
I mean, if you wish, Ms. Young, but that is going beyond and above what you're required to do.
Yes, Your Honor.
He's
Can
logged
someone-
on for me.
Can someone send me the DV bench warrant? I have one, but it's for next week, not today. I don't know why.
Ms. Spear, I'll send it to you, but FYI, it's attached to the SAP calendar that you originally got. It's the comp calendar, the SAP calendar, and the DV calendar. All three of them are together, but I'll send it to you again.
Okay, thank you.
You're welcome. Yes, G Spear, what's your first name?
Jennifer.
Thank you. My mind went blank.
That's okay. I've been gone a while.
Good morning, Miss Man. It's Chanel. How are you?
All right, with all
Good
parties
morning.
returned, all right,
Sorry.
we're ready to commence the DV bench warrant calendar. This calendar is for those individuals who currently have a bench warrant and they're requesting that it be set aside based upon some facts that will be presented and discussed today. We're going to begin first with the first position. Oh, give me 1 second. Case number 25 CR 003984F. Christopher Caballero is charged with simple battery family violence with the offense date of July the 13th of 2025 and must have missed a calendar. So I'm going to listen first to the state, Mr. Caballero, then I'll hear from your attorney to see if the bench warrant will be set aside or whether you will be required to surrender yourself within 72 hours to the Fulton County Jail. I do want to make you apprised you have certain rights, including the right to remain silent and the right to counsel, and I'm conducting this hearing by video. Do you understand your rights?
Yes.
All right, thank you, Ms. Spear.
Actually, Your Honor, my Odyssey just crashed. Could we maybe do this backwards?
We can, but it's not going to be as helpful.
Okay. Give me a minute then.
Mr. White is gonna. Okay, we can hear from Mr. White, but go ahead, Mr. White, if you want to tell us where your client was and perhaps why he missed. And in the meantime, Ms. Young and Ms. Strong, will you tell me if you see any return to services on the file? And you're muted, Mr. White.
Sorry, Judge. Judge, Mr. Caballero's address is correct. He just did not receive notice. He missed court on the 4th of May. This is the first time he's missed court. I'm just double checking. It looks like was for a plea in arraignment calendar, so that would make sense. We're just asking to set aside the bench warrant today.
So what happened? He didn't get it? What happened? He
He
just
did not receive notice. So I'm not sure why, but
the notice was sent, and there was no return on the file. So what I'm concerned is we're gonna have this same situation again.
Judge, I've explained to him that he can check the website every couple of weeks and also call the clerk's office every couple of weeks to double check. But we can also, I can give you the address to make sure we're all on the same page.
You've already served 16 days.
Okay. What address is on file, Mr. White?
I'm not sure what.
Well, not on. Well, let me say this. What address do you have?
I've got 6228 Valdez. And I'm sorry, was that a street or a road?
40 hours. And you couldn't have any contact.
And Miss Young or Miss Strong, is that the address on file for him? I'm asking this. I understand he's only missed one time, but I'm not hearing a really compelling reason for me to set this aside yet. Miss Spear.
You would have to take 12 hours process.
I just got my Odyssey back up and plugged this case in. Give me just a second.
On the
That's in here. And it's Drive in the system, Mr. White.
I'm sorry, Drive.
Yes, sir.
Okay, so being that we have the correct address, no returns, Your Honor, we would ask that it stand, especially like that it's family violence charges.
I'm not hearing why.
Well, just because typically you get.
I know you might get one, Mr. White. I'm not saying that but usually there's something more than I just didn't get it.
I understand. If I can finish, he found out he's been reporting to pretrial regularly. His pretrial officer is the one that informed that he missed the court date, and so he immediately scheduled for this. So, he's doing everything he's required. He can't go take the mail and deliver it himself. Sometimes mail gets lost. So.
Okay, making sure you finish, Mr. White. All right. Let me take a look at one more thing. All right, I will reset it one time and set it aside. You will not get another set aside, Mr. Caballero, and typically I require a little more than what's been presented today. So you really are getting the best of the grace that I have. Make sure your address stays current, that you check on this case monthly, if not weekly, to make sure that you don't miss anything else, because again, this was your one free pass, okay? All right, best of luck to you. I'll set aside that bench warrant in this case, okay?
Your Honor.
Thank you.
All right, let's move to position 2 on the DV reset. Oh, maybe we're not. Hold on one second. I don't understand what's going on with this today.
Odyssey is acting up, Your Honor.
It's really bad. I
Real
mean,
bad
it is.
today.
I keep having to hit Control Alt Delete to shut down Odyssey and bring it back up. It's getting
I'm on, and it's because I'm on this VPN. It's slowing the entire. This is very frustrating. Okay.
It's at work too, so it's just not your VPN. It's acting crazy.
It's so slow. Okay, 26 CR 001863C, the case in which Miss Golden is charged with battery family violence. Miss Spear, the state's physician. Miss Golden, you have a right to remain silent. You have a right to an attorney. Do you understand your rights today?
Yes, ma'am.
All right, Miss Spear.
I am trying to pull up to see if we have any returned senders.
I don't see any at this time.
I don't either. Are you still at Overlook Drive, River Overlook Drive?
And Mr. LaScala is here for her. Mr. LaScala?
I'm here. Just walking out of court.
Hi, always
Hey,
a pleasure
Mike.
to see you.
Hi, everybody.
How are you today? All right,
Wonderful.
we're not seeing any return to service on your client's screen. Miss Spear, what did she miss?
Let me go back real quick. Yeah, plea and arraignment May 8th.
Huh.
Okay.
I got to be honest with you. I got her out of jail. Even I didn't know about that date. So I apologize.
No one seems to have any, usually I get much better stories.
Yeah.
My grandmother was arrested. My toe was broken. I got none of that today other than just
I
the
was
mail.
there. I was there at the jail. I didn't get noticed. No one told us anything. I apologize.
Okay. Let me look at one thing. It was what judge is she assigned to? Let me see.
Thought I saw Edie, but hang on.
I
Dixon.
thought it was, yeah, it's Dixon.
Dixon.
Judge Dixon. All right. I am gonna set aside the bench warrant. This one time, Mr. LaScala, again, this is the one-time pass. She's not gonna get another one. Next time it'll be that 72 hours surrender. Please, both of you, keep track of this case by checking on it regularly, weekly, if monthly, if not weekly. All right, I will set aside the bench warrant this one time.
Thank you. And you have my entry of appearance in there, right?
Let me check. Yes, I saw it.
I just can't believe Cardita wouldn't have called me.
That is usually what does happen, and that's why I'm very surprised.
Yeah,
So,
I'm not sure. Anyhow, but thank you. We'll figure it out.
Okay, and please do check in with her. All right, take
thanks
care.
a million. Bye-bye.
All right, bye-bye. All right, bye-bye. All right, the final case on our calendar, that party has not appeared. So the bench warrant will stand.
And I did give him a call and I sent him an email.
All right, the bench warrant will stand.
I'm sorry, Ms. Young, you said you called and what?
I called him and I emailed him with the link.
Okay, fair enough. Thank you.
You're welcome.
All right, the bench warrant will stand. The DV reset case is now concluded. All right, Mr. White, does that conclude your business?
Thankfully, yes.
All right, take care. Have a good day. Miss Spear as well?
Yes, Your Honor. Thank you.
All right, take care of the day. And Mr. Caballero, you've been free to go for quite some time. You're free to go. Take care. Have a good day. If we could take the plea first on our 11 o'clock, I'd appreciate it. If possible.
Thanks. I'll get my working. It's Mr. Sands, who is, I believe, number 6 on down.
He wants to take the plea?
That is correct.
Okay.
You sound very surprised, Miss Tucker.
Yeah, I'll look up what the credit for time served is, but there's definitely additional jail time.
Yeah, I believe he served 16 days. I did let him know the state's offer, and I think he understands his options, Judge, and is able to proceed today.
This is our shortest competency calendar. I want to confirm it's only 6 people on here today.
It's the shortest calendar we've had in a while.
And it feels suspiciously short. All right.
I don't think there are going to be any real contentious matters today.
Okay. I'm used to seeing several people on our competency that we're checking on. All right. Oh, it went away. I don't understand. Give me a second. Thank you all for your patience. This is really frustrating. Once again, it's like it crashes.
The internet is in and out.
It's just really not ideal. Okay, I'm gonna have to download this and not try to look at it here, and then I can keep it up. Okay, thank you. Mr. Sands, your case today is 20, no, that's not you. It's on a different page. Oh, that is you. 26 CR 00262926K. You have one charge that will not sound, a simple assault charge, and an obstruction of law enforcement charge. You have a right to remain silent. You have a right to an attorney, and Mr. Bartels is here to represent you. And I am conducting the hearing today by video. Do you understand your rights and how I'm conducting the hearing? Is that a yes?
Yes, ma'am.
All right, thank you. Ms. Tucker, if you would just put the recommendation onto the record.
Yes, Judge. On count 1, it's going to be 12 months to serve 180 days. Credit for time served 16 days. Balance probated. To complete the MHET, complete 40 hours of community service, and have no further contact with Tiffany Graham. On count 2, simple assault, it's going to be 12 months to serve 180 days. Credit for time served 16 days. Balance probated. To complete 12 weeks of anger management. Again, to have no contact with Tiffany Graham and have no weapons while on probation. And then count 3, obstruction is 12 months to serve 180 days. Credit for time served 16 days. Balance probated with that statutory $300 fine.
All right, was that your understanding of the offer, Mr. Bartels, and do you so stipulate to the 3 elements in this case?
That's our understanding of the offer, Your Honor. And again, I have advised Mr. Sands of his options. He indicated that he did want to accept the state's offer. We would stipulate to the 3 elements for purposes of the plea, and he will, have some things he'll need to spend some money on. So we would ask if the court would consider waiving the first 2 months of probation fees.
I'm sorry, Ms. Tucker. The requirements again were the evaluation, and what was the other thing he had to do?
MHET, and then 12 weeks of anger management. Those he'll have to spend money on. Oh, and the $300 fine.
Okay, understood.
He also had a requirement of 40 hours community service, but
all right, I will waive 3 months of fees in light of those requirements. If you wish to take the plea today, Mr. Sands, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge? No. Is that a yes? We need to speak as loudly as possible. No. All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? No. Did anyone force you to take a plea today? No, ma'am. Did anyone promise you anything in exchange for taking the plea? No, ma'am. And you understand that by taking a guilty plea, you're giving up your right to trial by judge or jury? Yes, ma'am. And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt? Yes, ma'am. And you further understand that taking a guilty plea can affect other aspects of your life, such as employment, probation, immigration, and other matters? Yes, ma'am. And you're fully satisfied with Mr. Bartels' representation? Yes, ma'am. All right, as to the charges previously listed in the case ending in thought that was gonna be more simple. In the case ending in 2926K, how do you plead, Mr. Sands? I accept your guilty plea at this time. Is there anything additional from the state of defense?
Nothing further from defense. Thank you.
All right, your case is now closed, Mr. Sands. Best of luck to you. All right, and we don't need any other pleas, correct?
Nothing else, Your Honor, just status and recess.
All right, thank you. Then, Miss Mann, take care and have a wonderful afternoon.
Thank you.
All right, there
Thank
is.
you. Y'all have a good one.
All right, bye-bye. There is one party, so we do need to go into, Ms. Dahlworth can be excused as well. We do need to go
Thank you.
into a breakout because there is, one person, I think.
Yeah, who is Ms. Jones? Dana Jones?
All right, we're gonna go into the breakout session just in case. All right, can we, be placing the breakout, pretty much everybody with the exception of one person?
I'll see you, Doc. Yeah. Let's see, 74 more days. I'll check to make sure.
All parties are gone and we are complete. We'll be in recess till the next state all-purpose calendar. Take care, everyone. Bye-bye.